Start చేయమంటారు. Hello everyone, welcome to MVC Academy. This is Santosh Koka, Faculty of Polity and Governance. So today only you have attempted out of totally 25 questions, important questions from Polity section, right? So in this video we will check the important key and also important explanation for those 25 questions, right? Let's start. So first important question, which one of the following best describes the doctrine of harmonious construction as applied by the Supreme Court of India? So first option, it is used to resolve conflicts between fundamental rights and directive principles of state policy. So and also it is a principle of statutory interpretation where two or more provisions of a statute or constitute are interpreted so that each is given effect. So it is principle that allows the parliament to amend any part of the constitution including fundamental rights. So it is the doctrine that prevents the executive from encroaching upon the domain of the judiciary. So these are the options. So whenever you see the important topic related to the polity, so we have to retain the exact topic from the options itself. Sometimes we can eliminate those options also. So first of all, if you see the doctrine of harmonious construction especially, so what is it? So if you see in the constitution, in the Indian constitution, we have number of provisions related to the powers and functions of different authorities, and also we have powers or duties and also responsibilities. Apart from that, we have some certain rights or safeguards of related to our fundamental rights, or some other safeguards of human rights, especially related to the particular citizens also, right? So here, whenever there are any particular conflict happen between these provisions, especially provisions related to that particular law or whatever we have the constitutional provisions, right? So whenever there is any conflict in between two or more provisions, then what will we do, right? So that is the court interpretation. Here court can interpret in these situations whether those two or similar provisions may apply or neither the particular whatever we have constraints or provisions not applied, right? So thus this is the doctrine of harmonious construction. Whenever the conflict happen like this, the judiciary will be involved, right? That is the interpretation, judiciary interpretation, right? It is a principle of statutory interpretation where two or more provisions of a statute or construction are interpreted so that each given effect, right? So apart from that, if you see, it is used to resolve conflicts between fundamental rights and directive principles of state policy. Is it doctrine of harmonious construction? No, it is completely doctrine of basic structure, right? So that is completely different, right? So only B is the correct option here. So next, if you see the second question, consider the following statements regarding the office of the pro tem speaker, right, is mandatory, right? So in the Lok Sabha, right, what is pro tem speaker? Completely this question is related to pro tem speaker. It is appointed by the President of India, holds office until the new speaker is elected. Primary duty of the pro tem speaker is to administer the oath to the newly elected members of the house. These are the two important statements. What is pro tem speaker here? So as a convention, we are completely focusing on this pro tem speaker whenever the general elections completed in the whether it is in state or center. So immediately in the first sitting of the session, this pro tem speaker means, pro tem means here it is a Latin term meaning for the time being, right? For the time being, right? So for the time being, a person will be acted as a temporary speaker here, right? Temporary speaker is called pro tem speaker, right, until the original speaker will be elected. That is the main important thing. So he will administer each and oath related issues, the important members of the oaths also, and also the speaker and deputy speakers oaths also he will administer. So those are the important functionalities here. So he is completely appointed by the president, that is correct. He holds office until the new speaker is elected. So if it is, he is appointed by the president in central, right, means central government. So if it is in state, he is appointed by the governor, right? So that is we have to understand. Primary duty of the pro tem speaker is to administer the oath to the newly elected members of the house, right? So that is correct. So completely these two statements are correct, right? So both 1 and 2 are the correct option here. So next question, with reference to the concept of constitutional morality, consider the following statements. It is explicitly defined in the preamble to the Constitution of India. It implies adherence to the core principle of the Constitution even if they are not explicitly codified in a specific article. So the Supreme Court has used this concept to strike down laws that violate the spirit of the Constitution, such as in the Sabarimala case, right? So these are the three important statements were given related to the constitutional morality. So it is explicitly defined. Is it explicitly defined? No. So here it is not explicitly defined in the preamble to the Constitution. So we just included the importance. The constitutional morality means here constitutional ideals, right? Some ideals we have. In the spirit of Constitution only we can take this morality, constitutional morality, but not defined exactly constitutional morality, right? This is wrong statement, and also it implies adherence to the core principles of the Constitution even if they are not explicitly codified in the specific article, right? So completely it is not included in the specific article. If you see some particular things, for example, equality we have, liberty we have, right? So fraternity we have. From these terms we can tell these core principles of the Constitution. Those are core principles of the Constitution that was included in the preamble, right? So even if they are explicitly codified in a specific article, right, especially they were included but not completely related to constitutional morality, right? Not defined as a constitutional morality, but a spirit, as a spirit of the Constitution we are following, right? So the Supreme Court has used this concept to strike down laws that violate the spirit of the Constitution, such as in the Sabarimala case, right? So even though if you see the Sabarimala case, right, 2018 especially versus Union of India versus 2018 Kerala case. Apart from that, if you see the particularly, so deregulation of the section 377, right, that is also very important here, right? For these important phenomenon, Supreme Court has already used this concept, constitutional morality, right? So here we are taking these core principles of the Constitution, equality, liberty, and also fraternity as specific efforts, means spirit of Constitution we are taking instead of explicitly mentioned or defined constitutional morality, right? So here only 2, means 2 and 3 are the correct option. So next, if you see the fourth important question, consider the following statements regarding the powers of the governor of a state. Governor can reserve a bill for the consideration of the president only if it endangers the position of the High Court. The governor has the power to pardon, reprove, respect, remit punishment, etc. So these are the complete powers, granting powers, pardon powers having the governor, so same as president. And also governor acts as the chancellor of state universities and appoints vice chancellors. Governor can make ordinance when the legislative assembly is not in session, but the ordinance must be laid before the assembly when it necessary or reassemble, right? So these are the 4 important statements related to governor. If you see, governor is the very much important topic in our polity subject. Why? Because it is completely, whenever you take president and governor, those are very important topics. Apart from that, governor issues are ongoing issues or debate related to the discretionary powers, etc. We have been seeing in the newspapers, right? So here if you see governor powers related question, here governor can reserve a bill for the consideration of the president only if it endangers the position of the High Court. It clearly states that only, not only. Here governor can reserve a bill for the consideration of the president in 5 instances here. What are those? So whenever the particular bill ultra-vires, right, ultra-vires the Constitution, that is one instance. Apart from this, endangers the position of the High Court also. Whenever the bill endangers the position of the High Court, that is also one case. Other than that, So this is second one. Third important thing, if it is opposite to the DPSPs, right? Right. So if it is violate the fundamental rights, right? Apart from that, if it is against the national importance, right? So national importance or public importance also, right? Overall interest of public against overall interest of public or against the national importance, right? All these are important, 5 important considerations, or we have features whenever the governor can reserve a bill for the consideration of the presidents, not only this one, right? So this is wrong. So if you see, the governor has the power to pardon, reprieve, respite, etc. All these information is correct according to whatever we have according to Article 161. But if you take, this is the complete correct statement. If you take the president, right? If you take the president powers related to this pardon, right? That is completely different, right? So that is, governor cannot pardon death sentence or sentence by a court martials, right? So that is the difference. President can do it, right? So this is the difference, but this statement is correct according to the governor powers. So governor acts as the chancellor of state universities and appoints vice chancellor. This is also correct statement, right? So governor can make ordinances when the legislative assembly is not in session, but the ordinance must be laid before the assembly. Same as president, what we have. This is completely according to Article 213. From this 213, governor can make ordinances, right? So likewise, according to Article 123, president can do the ordinances, right? So this is the difference. Whenever you particularly reading a topic or completely related to one topic, we have to relate to other topic in the polity, then only we can remember, right? So that is the difference, most difference between powers between the governor and president here. So only first option is wrong. So 3 options, only 3 means 2, 3, 4 are correct. Next question, which of the following statements about the Attorney General of India is not correct? So they are asking for incorrect. So he must be a person who is qualified to be appointed as a judge of the Supreme Court. He has the right to speak and take part in the proceedings of both houses of the parliament. So he is a member of the central cabinet and can vote on matters before the cabinet. He holds office during the pleasure of the president. So certain offices or authorities holds office during pleasure of the president, we have already discussed. So apart from the prime minister, so we have council of ministers, right? All the attorney general also including here, right? So this is correct. Apart from that, he must be a person who is qualified, appointed as a judge of the Supreme Court. So here attorney general is the highest law authority, right? Highest law officer in the entire country, right? So that is the first important thing. He has to be qualified as a Supreme Court judge. So he has the right to speak and take part in the proceedings of the both houses of parliament. That is his right according to Article 88, right? So here he is a member of the, is it a member of a central cabinet? No. So he can't vote on matters before the cabinet, right? So he just sat into the particular houses and right to speak and can part in the proceedings. That's it, right? So here he is not a political functionary. That has to be remembered here, right? So only B is the, only C is the wrong option here. So they are asking for not correct only. So C is the correct option. Next important, consider the following statements with respect to the 42nd Constitutional Amendment Act 1976. It added 3 words, that is new words, socialist, secular, integrity to the preamble of the Constitution, and also it made the president bound by the advice of the Council of Ministers. So here if you see, the 42nd Constitutional Amendment Act 1976 is we generally called as mini constitution. Why? It has only included so many number of changes were included in this particular amendment, right? So from this amendment, very importantly, we used to call it as a mini constitution. So it added 3 new words, socialist, secular and integrity to the preamble of the Constitution. That is completely according to the 42nd Constitutional Amendment Act, right? So very, very important. This is correct, right? So apart from that, it made the president bound by the advice of the Council of Ministers. Is it correct? Right. Yes, definitely. So if you see the Article 74, according to Article 74, the Constitution, according to Article 74 of the Indian Constitution, the president must be bound by the advice of the Council of Ministers. This is the rule given or added by the amendment of the 42nd Constitution Amendment 1976. But it was completely overruled or just changed in the, particularly this particular article changed in the 44th Constitutional Amendment Act, that is 1978. What was the change? Completely here. So he can return the bill, right? Here he can sometimes reconsider, return the particular consideration or advice for reconsideration once, only once. That was the change given by the 44th Constitutional Amendment Act 1978, right? So here, if you see, both two statements are correct only, right? According to 42nd Constitutional Amendment Act, the president must bound by the advice of the Council of Ministers. That is right. But after 44th Constitutional Amendment Act 1978, it was changed, slightly changed, for the permission of the reconsideration only one time, right? So only both and 1 and 2 are the correct. Next, with reference to the Delimitation Commission in India, consider the following statements. The orders of the Delimitation Commission have the force of law and cannot be called in question before any law, right? The commission is a permanent body established under Article 82 of the Constitution. So here the last Delimitation Commission was set up after the 2001 census. So delimitation is very important process. As of now, after the Women Reservation Bill has included or enacted as a bill, we are waiting for a census to implement the Women Reservation Bill. Here two hurdles are there to implement the Women Reservation Act. Here first of all census, second delimitation, right? So here immediately after the census, we have to include or start the delimitation process, right? So whenever we want to conduct any type of elections, this delimitation process is very important, right? So that is just dividing the constituencies based on the geographical territory, right? So here based on the population, geographical territory here, right? So this is very important process. If you take, in order to the orders of the Delimitation Commission have the force of law and cannot be called in question before any court. Here if you see, after 1951 census, first we have conducted this delimitation process 1952, right? After that we had conducted in 1962 also, and also 1973. Till 3 years we had been conducted continuously. After that several gaps were there, right? So again in 2002 only we just completed, that was the last time delimitation was conducted, right? Only 4 times we were conducted the delimitation process. So the commission is a permanent body established under Article 82. So it is right, this commission is established under the Article 82 of the Constitution, but it is not a permanent body, it is a temporary body. So time to time, means after census only the delimitation commission will be established based on the requirement, right? Not a permanent body. The last delimitation commission was set up after 2001 census, that was in 2002. This is also correct, right? So only 1 and 3 are the correct. Here only 2 statements are the correct statement. Next, the concept of due process of law is a feature of the Indian Constitution that is primarily derived from, so due process of the law, right? So completely it is from Constitution of the United States, right? So if you see, by the convention we have been following the procedure established by law, right? So that is our important convention rule, right? So after, if you see the Maneka Gandhi case, so 1978 we have just including the article, just recreating the article 21, right? Included the due process of law here, right? So according to the article 21, here article 21, we just included the due process of law by these inclusion in the Maneka Gandhi case 1978. So just we extended the or expanded the fundamental rights, right? Especially article 21, the definition of the article 21, right to life, we have just expanded the article 21 here. So that is the important issue here. So other than procedure established by law, we just continued with due process of law that was derived from the United States, right? We just borrowed from that, right? So next, if you see the which one of the following is not a fundamental duty as enshrined in the Constitution of India, these type of questions also will be reflected in the UPSC, right? Some sort of easy, some sort of tough, some sort of average questions also will be reflected, right? To safeguard public property, this is correct, and to protect the improve natural environment, to strive towards excellence in all spheres of individual and collective activity, also correct. If you see, to pay taxes and duties to the government honestly is not a fundamental duty here. Why? Paying taxes is a legal obligation, not a fundamental duty that we have to observe here, right? So here the simple logic, that is paying taxes and duties to the government honestly is not a fundamental right. It is a legal obligation on the citizens, right? So that is simply not correct, not fundamental duty is C. Next, if you see, consider the following statements regarding the money bill in the parliament. A money bill can be introduced only in the Lok Sabha and only on the recommendations of the president, and also Rajya Sabha must return the money bill with or without recommendations. A final decision on whether a bill is money bill rests with the speaker of the Lok Sabha. So the president can return a money bill for reconsideration of the parliament, right? So here number of important statements were given related to money bill. If you see, money bill can be introduced only in the Lok Sabha and only on the recommendations of the president, right? Whenever the president recommended a money bill, it will be goes to the Lok Sabha, right? So it is correct, Rajya Sabha must return the money bill with or without recommendations within 14 days. This is also true. So Rajya Sabha does not have much more powers related to money bill here. So final decision on whether a bill is money bill rests with the speaker of the Lok Sabha. So with the prior recommendations only from the president only, it will goes to the Lok Sabha, but finally whether it is the bill is a money bill or not, it is the main authority to decide, the speaker, right? President can return a money bill for reconsideration of the parliament? No, he cannot return. Why? What is the reason here? He cannot return a money bill for reconsideration. Why? It is just from the prior recommendation of the president only, it is moving to the Lok Sabha, right? So again, it don't have that particular power, right? President can return means cannot return, right? Money bill, that is the main important thing. So it is wrong statement. 1, 2, 3 means only 3 statements are the correct. So consider the following statements regarding the office of profit in the context of disqualification of a member of parliament. Here Constitution of India defines the term office of profit. So and also parliament has the power to declare by law any office shall not disqualify its holder from being chosen as a member of house, right? Parliament. So here office of profit, is it defined in the Constitution? No. This office of profit is not defined here, right? Completely not defined in the Constitution here, right? So this is just a convention. We just taken in the convention only, right? So office of profit is not mentioned in the Constitution. This is wrong. So parliament has the power to declare by law that any office shall not disqualify its holder from being chosen as a member of parliament, right? So here from this power only, right, parliament has the power to declare any person here, office shall not disqualify, right? So final authority here to decide on the question of disqualification of a member on the ground of holding an office is president in accordance with the opinion of the election commission. If you state any MP related things here, right, so president give the prior main permission here, right? So in accordance with the election commission only. If it is MLA, governor give the permission, right? That is the difference here. So these 2 statements are correct here. Only 1 statement is wrong. So only 2 means B is the correct option. So which one of the following statements regarding the writ of mandamus is not correct? Here writ of mandamus means it is just we command, right? That is the meaning of this mandamus here. So thus it is completely related to the issue to the public officials, whether they are doing the work or duty of their responsibility or not, right? It is a command issued by the court to public official asking him to perform his official duties that he has failed to refuse to perform, whether it is public duty or public official or any government also, even including government also it can issue, right? So other than that it can be issued against a private individual or body? No, only for the public officials or corporations or government especially, right? So completely related to public official only. If any private individual, if he do the public work, if it is applicable, it can be issued, right? That is the difference. It cannot be against a private individual or body, right? So it cannot be issued against the president or the governor, right? That is also correct here. So only public officials and also government officials and also some corporations only applicable. So it can be issued to enforce a fundamental right. Whenever this particular writ of mandamus, why we commanding means whenever the officials' duties are not performed better as per the rules and regulations, here the violations of the fundamental rights only will be observed, right? So that is the main important issue here. So here the B is the correct option. So next, consider the following statements regarding the emergency provisions in the Indian Constitution. So we have already discussed in our previous classes emergency provisions. First of all, Article 350 we have national emergency, right? Article 355 we have state emergency, that is President's rule, and Article 360 we have financial emergency, right? So here proclamation of national emergency can be issued by the President only on the written recommendations of the Union Cabinet, right? So this is completely given by the 44th Constitutional Amendment Act, right? 78, right? So this is correct. President only on the written recommendation of the Union Cabinet only can issue the proclamation of the national emergency. So proclamation of financial emergency requires approval by both houses of parliament within 2 months, right? This is also correct. Financial emergency, here if you see the financial emergency and state emergency, parliament has to give his approval, its approval within 2 months. That is the time period here. But related to national emergency, 1 month is sufficient, right? That is the difference between national emergency and state emergency, financial emergency. Once approved, a proclamation of financial emergency continues indefinitely until revoked by the president. Likewise, state emergency also, right? State emergency and financial emergency same, right? So continuously they can. A proclamation of president's rule in a state must be approved by the parliament within 1 month. Here state's rule relatedly, if you see president's rule within 2 months, not 1 month here, we have to understand, right? So for national emergency only it is 1 month, right? So 1, 2, 3 are the correct. Here only 3 options are the correct options, remaining fourth option is wrong. So with reference to the right to internet access in India, consider the following statements. So right to internet is very important, right? So Supreme Court has explicitly declared the right to access internet in fundamental right under Article 19(1)(a) of the Constitution. If you see the Article 19(1)(a), freedom of speech and expression, and Article 19(1)(g), if you see, same freedom of right to provide the trade related to internet also, right? Do any business related thing, right? So these are the two important. Based on the two important, Supreme Court has explicitly declared the right to access, right? So this is also completely related to our Article 21 related things only, right? So any restriction on internet access must be in accordance with the principles of proportionality under Article 19(2), right? So 19(2) articles are completely related to the grounds, specifically grounds related to them. So restrictions on freedom of expression, especially 19(1), especially whatever we have seen, right? 19(1)(a) to (g) are completely or becoming a 16 democratic rights we have, right? So very, very important. So both these two are correct here, both 1 and 2. Next, consider the following statements regarding the Panchayat's extensions to Scheduled Areas Act 1996 here. So first of all, PESA applies to 5th scheduled areas of the country, right? So this is correct, completely related to part 9 of the constitution here. So very important, scheduled areas, some of the 5th scheduled areas are extended PESA here. So and also empowers the Gram Sabha to safeguard and preserve the traditions and customs of the people, their cultural identity, community resource, and the customary mode of the dispute resolution. Whenever they have just Gram Sabha completely empowered to safeguard the and preserve the rights of the our tribal people here, right? So that is the main important thing. Just Panchayat extensions, scheduled areas, right? So 5th scheduled areas are the very much important here. State legislature is barred from making any law that is inconsistent with the customary law, social and religious practices, and traditional management practices of community resources of the scheduled tribes here, right? This is completely central government. 5th schedule or part 9 is completely related to central government only. State legislature is completely barred. There is no power for the state government to do anything here, right? So these 3 are correct, all 3. C is the correct option. The shadow cabinet is a concept associated with the which of the following political systems? Shadow cabinet is completely related to Britain's parliamentary system, right? So it is, shadow cabinet means completely resembles the working of the government cabinet, means it is a opposition thing, right? Opposition party will act as a shadow cabinet, that is completely resembles with the government cabinet, right? So next, which one of the following statements about the Council of Ministers at the union level is not correct? Right, Council of Ministers relatedly, the total number of ministers including the Prime Minister and the Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. That is completely mandatory. A person can be appointed as a minister even if he is not a member of either house of the parliament, but he must become a member within 6 months. If he just coming to the appointment or election, just if he appointed another unauthorized person, if he appointed as a minister, completely within short time, means 6 months, he has to become a member, right? So the ministers are individually responsible to the president. Advice tendered by the ministers to the president shall not be inquired into any court, right? So this is completely related to Article 74, right? So president bounded by the advice of the Council of Ministers, right? So cannot be inquired into any court. That is also very important, right? Correct option. So the ministers are individually responsible to the president. This is not correct. So they are collectively responsible. Collectively responsible to the Lok Sabha, right? That is the main important feature in the constitution, right? So here the ministers are collectively responsible to the Lok Sabha, but individually responsible to the president. Some extent, means this particular question is some sort of debatable question, right? If you see in UPSC, these type of questions may ask as a particular debatable question here, right? So ministers are sometimes individually responsible to the appointment, or sometime if you see they can removed by the president, right? So from that particular context, we can say the individually responsible to the president, right? So but if you see the holistically, whatever we have mentioned in the constitution, collectively responsible to the Lok Sabha only, that is completely different. We have to understand the positive mainly mentioned in the constitution only. We should not deviate from the UPSC point of view here, right? So ministers are individually responsible to the president is not completely right, partially right, right? We have to understand the main feature, that is collectively responsible to this Lok Sabha only. If he means ministers completely individually, they are practically, if you see the reality, in reality individually are responsible to the president only, but according to the constitution we have to obey this first of all, right? That's why it is wrong. So C is the correct option here. Consider the following statements regarding the judicial review power of the Supreme Court of India. Power of judicial review is explicitly mentioned in the Article 13 of the Constitution. Scope of judicial review was significantly expanded after the introduction of due process of law. We have seen this, right? So whenever the 1978 Maneka Gandhi case, so then we shifted to the introduction of due process of law, right? So here judicial review can be used to examine the constitutionality of both legislative enactments and executive orders. What is judicial review here? Judicial review is when any actions of legislative or executive or administrative are completely violating of the constitutional provisions, then judicial intervention will be there, judicial review will be there. That is the concept here, right? So here it can be used for the actions of the legislative and executive orders. Power of judicial review is an essential feature of the constitution and forms part of the basic structure. This is also we can say from the Maneka Gandhi case, and also basic structure related thing if you see the Minerva Mill case, right, 1980, right? So that is also very important. So apart from that, if you see the important power of judicial review is explicitly mentioned in the Article 13 is not correct here. Article 13, other than Article 13 we have so many articles, right? Article 31, Article 32, and also Article we have other important articles related to it, right? So we have 313, right? So other than Article 13 we have Article 31, 32, other than so many articles are there. So judicial review explicitly mentioned in those provisions, right? Not only Article 13, that's why it is wrong, right? 2, 3, 4, only 3 are the correct. So with reference to the office of the whip in the Indian Parliament, consider the following statements. It is mentioned in the Constitution of India. Is it mentioned office of the whip? No, it's just a formality, right? So it is a conventional rule only, it is a convention only, traditional practice only. It was not mentioned in the Constitution. Whip is responsible for ensuring the attendance of the party members and regulating their voting behavior in the house. It is just to protect or to control the behavior of them, right? So just formality. So only second option is the correct. Next important, consider the following statements regarding 0R in the Indian Parliament. It is an informal device that is not mentioned in the rules of procedure of the House, and it starts immediately after the question hour and lasts until the agenda for the day is taken up. During 0R, members can raise matters without any prior notice. So 3 statements, if you see both, you may consider both, all 3 are correct. But if you see third statement, so first of all start from the second statement, it starts from immediately after the question hour, so lasts until the agenda. If you know the the session starts from 11 AM, right? So immediately after starting the 11 AM, first of all question hour, right? Question hour will be started from 11 AM to 12 PM, right? So it may be cut from 12 PM to 1 PM, right? So 0 hour can be conducted in this during this period only, right? So it is an informal device that is not mentioned in the rules of procedure of the House. That is correct. So not mentioned. So question hour, after question hour only it will be applied. So during the 0 hour, members can raise matters without any prior notice. This is correct some up to some extent, but for the public importance, whenever the issues are related to any matters are related to public importance, there is no need to take a prior permission, prior notice. But normal things, they have to take permission around 10 AM only, right? So before 10 AM they have to take the prior notice, give any prior notice. That is the condition here. This is wrong statement, only 2, means only 2 statements are the correct. So which one of the following statements regarding the adjournment motion in the Parliament is not correct? So it is introduced in the Parliament to draw the attention of the House to definite matter of urgent public importance, right? So it is correct. So draw attention of the House to definite matter of urgent public importance, right? So it is some sort of cessation, right? Or censure, we can say, stopping the particular motion, right? So it involves an element of censure against the government. It requires the support of at least 50 members to be admitted. It can be moved in both Lok Sabha and Rajya Sabha, right? If you see, this adjournment motion is only applicable in Lok Sabha only. Why? It is completely related to censure against the government, right? So it is not applicable in the Rajya Sabha, right? So it is a censure against, element of censure against the government. This second statement only giving the fourth statement is wrong, telling completely the fourth statement is wrong. It can be moved in only from the Lok Sabha, not Rajya Sabha. Why? Because it is a element of censure against the government, right? So fourth statement is wrong here. So D. Next, consider the following statements regarding the electoral bond scheme. So it is very important. Recently it was unconstitutionally stopped, right? So the scheme was introduced to ensure complete anonymity for the donors of political parties. Only political parties registered under section 29A of the Representation of People Act 1951. This is also correct. Supreme Court of India struck down the scheme, holding it to be violative of the right to information under article 19(1)(a). So the bonds were issued in multiples of 1,000, 10,000, 1 lakh, 10 lakh or 1 crore, right? So if you see, the scheme was introduced to ensure complete anonymity for the donors of the political parties. Especially this complete anonymity is not related to political parties but people, especially from the point of the people only, it is considered as a complete anonymity for the donors, right? So not the political parties here, right? It is not correct, right? Remaining three statements are wrong. Right, only three, means three statements are correct here. So next, if you see the, consider the following statements regarding the Council of States, means Rajya Sabha here. Representatives of each state in Rajya Sabha are elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of the single transferable vote. This is correct. Apart from that, the Constitution has fixed the term of office of a member of the Rajya Sabha as 6 years. The Vice President of India is the ex officio chairman of the Rajya Sabha. These are the three statements. If you see, this is the correct statement, and if you see, the Vice President of India is the ex officio chairman of the Rajya Sabha. So this is also correct. If you see, Constitution has fixed the term of office of a member of the Rajya Sabha as 6 years. That is wrong. Why? Constitution itself has not fixed the term of Rajya Sabha here. So that's why if you see the Representation of People Act 1951, means it is up to the Parliament only. Parliament can do this, can fix. That is completely given the powers to the Parliament, right? So that's why Representation of People Act 1951 decided or fixed the 6 years fixed time for Rajya Sabha, right? So Constitution has not fixed, right? So 1 and 3, only two statements are the correct. So if you see the next question, which of the following is the correct chronological order of the establishment of following constitutional bodies here? So these are constitutional bodies we have already discussed in the classes. Election Commission of India, Finance Commission, National Commission for Scheduled Caste, Union Public Service Commission. If you see, from these all constitutional bodies, Union Public Service Commission, this was not established in the after independence. Previously only it was established, means 1930 only. Federal Public Service Commission, as Federal Public Service Commission only, it was established in 1930. That's why first one is 4, right? These two A and C are up to some extent are correct. So next, if you see the Election Commission immediately after the independence only, right? 1950 only it was established, right? That is correct. Next one, 1950, that is 4-1. This is the correct. A is the 4-1. Next, if you see Finance Commission, so 1960, right? So in the 1960 only it was, from the article, we have article 280. So if you see the Union Public Service Commission after 1950 only, it was became the Union Public Service Commission, changed the name, right? So article 315, right? So if you see the Election Commission, article 324. So apart from the National Commission for Scheduled Castes, if you see, this particular body comes in the during 1990s, right? Initially, but after that separate bodies. I mean, initially 1990s, 69th Constitutional Amendment Act only, 67th or 5th, 67th, right? So 1990 only included National Commission for Scheduled Castes and Scheduled Tribes, that was separately divided in 2003 around times, right? So that's why here 4, 1, 2, 3. First of all, Union Public Service Commission. So Federal Public Service Commission, that was in 1930, first body. So second, Election Commission. Next, Finance Commission. Finally, National Commission for Scheduled Caste. So which one of the following statements regarding the tribunals in India is not correct? Tribunals, this is very important concept. They were added to the Constitution by the 42nd Amendment Act of 1976. Article 323A deals with administrative tribunals, while Article 323B deals with tribunals for other matters. These are two correct. So Parliament can establish a central administrative tribunal for the adjudication of disputes relating to the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union. Here, these tribunals, whenever we have been having so many pending cases in the courts, that's why because of that particular issue we have created this tribunal to deal with the pending cases, right? So as a quasi judicial bodies we have established these tribunals, right? So that is the main important issue. So the orders of the tribunals are final and cannot be challenged in the High Court. This is not correct. Why? Orders of the tribunal, if any decision taken by the tribunals or orders that completely reviewed by the high courts in the state and Supreme Court in the center, that is the very important thing, right? So here they cannot be challenged in the High Court, means it can be challenged, means the decision, final decision will be taken by the High Courts only, right? So that is completely related to High Courts. High Courts only will scrutinize or examine or review the decisions or orders of the tribunals here. Those are the final, right? So this is the these are the 25 important questions from the polity section you have already attempted. So but this is the perfect explanation. So if any mistakes are happened in this 25, you can comment in the comment section, right? We will rectify. So here all these are questions completely framed according to the UPSC new trend, right? So follow this trend, and also in the considering all these pattern and exam trend on newspaper, current affairs, we have to follow the polity, static and dynamic approach, right? Thank you very much. All the very best.